Hi, everybody. Ooh, excuse me. My throat is still off. Welcome, everybody. Make sure you guys are hitting that like button, please, and thank you. Shout out to everybody. Listen, it is Is it really Thursday? It is Thursday. Oh my God, can you guys hear me? Drop a one in the chat if you can hear me. Just making sure because I unplugged a bunch of things yesterday, and I didn't tell the people I was live. So let me do something. Let me play my intro to give me some time because I'm still not done setting up. And then we're going to get right to it. Let's go. Hold up. Wait a minute. Bruh. Did you hit the like button? Drop some rabbits in the chat. Let's go.
Hit that like, hit that like. Welcome to the chat. Let's chit chat, hit chat. Hit that like, hit that like. Drop some rabbits in the chat. Drop some rabbits, drop some rabbits, drop some, drop them, drop them, drop them, drop them. Drop some rabbits in the chat. Drop some rabbits, drop some rabbits, drop them, drop them, drop them, drop them. Drop some rabbits in the chat. Drop some rabbits. If you want the tea, come see me. Rabbit hole is the place to be for real news, not fake news. Celebrity news, breaking news around the clock. Real talk, best on the block. I rock, I rock, I rock, I rock. Real talk, best on the block. I rock, I rock. Hit that like, hit that like. Welcome to the chat. Let's chit chat, chit chat. Hit that like, hit that like. Drop some rabbits in the chat. Drop some rabbits, drop some rabbits, drop some, drop them, drop them, drop them, drop them. Drop some rabbits in the chat. Drop some rabbits, drop some rabbits, drop them, drop them, drop them, drop them. Drop some rabbits in the chat. Drop some rabbits. True crime is my specialty. Exposed in the industry. Unsolved mysteries. Sticking to reality. Fair use commentary. Talking about cults. Trying to get results. Exploring cults. Exploring, researching, debunking, investigating, being nosy, super nosy, being messy, being shady. Rabbit hole news. That's me, the chick with ADHD, unmedicated but quite educated. Hit that like, hit that like. Welcome to the chat. Let's chit chat, hit chat. Hit that like, hit that like. Drop some rabbits in the chat. Drop some rabbits, drop some rabbits, drop them, drop them, drop them, drop them, drop them. Drop some rabbits in the chat. Drop some rabbits, drop some rabbits, drop them, drop them, drop them, drop them. Drop some rabbits in the chat. Drop some rabbits. Hit that like, hit that like. Let's go, let's go. Let's start the show. Let's start the show. Let's start the show. Let's start the show. Let's start the show.
Hi, everybody. Good morning, good morning, good morning. At least morning on my end. I don't know what time it is on your side of the world. Shout out to everybody in the chat. Welcome, welcome, welcome. Let's get it together. I'm waiting for the sitter to get, sitter should be here pretty soon. All right. So we're gonna, I know I muted myself, y'all. I muted myself on purpose. Shout out to everybody in the chat. Can you guys hear me okay? Let me know. It says my mic is on, so hopefully it is. The mic? What's going on with the mic? Can you guys hear me? Let me know. Let me check something. Loud and clear. You said mic is not plugged in? Okay, give me 1 sec. Okay, can you hear me now? The mic, the sound was weird. I think I got it now. Let me know. I was messing with it. No, it's not just you. I think it was me. Think is it better? Drop a one if it's better now. Yes, it's better. Yeah, it's not you. I think it was my mic. So let me tell you, I've been messing with this. So I told you guys that I'm wanting to change to a different platform stream service because I'm tired of StreamYard. I've been using StreamYard for I don't know how many years now. And even though I'm used to it and I've liked it, I think it's time for me to say goodbye because it's so expensive at this point. And I want to do a little bit of I'm trying to learn OBS. So I'm getting there. I'm not there quite yet, but it's a little nerve-wracking with OBS, but we have the equipment for it. So we're going to make that transition at some point. Sorry, guys, I'm all over the place. I saw BJ's post, so we're going to talk about that here in a little bit. I got the transcripts for yesterday, which includes the verdict and the bail. So that's going to be interesting for us to talk about. We got that. I After this live, I'm definitely going to take like today and maybe tomorrow off because I am behind. I got to talk about Barry Morphew, which is a case that I want to follow, but I'm so behind on that. I got to talk about Sherry Papini. I want to talk about that one. Liam Payne. I'm saying this out loud so that I remember to go back in the video and figure out what I talked about. And there's another situation that I want to talk about, but I haven't quite decided how to tackle that topic yet. You said that the trial has been addictive. I think people are addicted to the trial at this point. Give me one sec, guys. Give me one sec, guys. We got the sitter coming through. You don't hear because I'm muted right now. Sorry about that. Okay. All right. Sorry. My sitter had to come in and take baby bunny for me. Baby bunny was sitting there. Okay. Yes, I know. There was no sound. I'm muted. So let's talk about BJ. I saw that she posted. I saw this actually on IG, and I'm hoping that, hopefully she'll likely do a video and follow up. A lot of you guys were asking me, hey, what's going on with BJ? Yada yada yada. And I was like, I don't know. I mean, because I had seen her in various videos from other content creators, so I assumed everything was okay. But it sounds like things kind of went down after the verdict yesterday. And I think we kind of expected. I don't know. I guess people got attacked outside of the trial and the courthouse, which I thought was interesting. I saw it was a little bit crazy, but I guess it went down. So BJ did write this post for us. Shout out to BJ. Let me read it. Excuse me, to everybody. Hold up. Had to clear my throat. Okay. Um, she says to everyone asking if I'm okay, I'm getting there. But yesterday I was definitely not. Yeah. And I will be recovering for a while. If you are wondering why I didn't go live yesterday on the biggest day of the entire Diddy case, it is because I was targeted and attacked by a group of deranged, haggard freaks literally the entire day. So, what I notice is that I just noticed that, yeah, certain people were getting attacked depending on what their commentary was. People got to be mindful that this is what was happening. And I don't know, like all of this was going down. That's what they said. They tried to silence her. I'm not really sure like why they would or what. Um, but this is what they tried to do. I'll be going live today or tomorrow to give y'all the full rundown of the entire trial day, including derailing the multiple attacks with pictures of the assailants. Multiple federal marshals had to intervene for my safety and the order of the institution of the federal courthouse. So the marshals had to get involved. Wow. Shout out to BJ, guys. Make sure you guys go check her out. Hopefully she goes live today, if not tomorrow, or at least takes a lot of rest. Y'all are literally not going to believe what these lunatics did and said. It was all very shocking and appalling, and I feared for my safety all day. The only reason I stayed was to let them bitches know I don't run from bullies, and I never will. I never hear BJ cuss, so she said bitches. Okay. Don't worry though. Of course, I stood my ground. And of course, I got pics and receipts and multiple witnesses. And we'll be showing you all what they try to do to me. Two of the lunatics are pictured below for reference. I literally cannot wait to tell y'all this story, but yesterday was completely ruined, and I'm still pretty shook about it. I know that there was an issue. I think I was reading an IG that one of them was trying to like not let people stand in the line or not get inside the courthouse. I mean, it definitely looks very serious, honestly. Um, so I'm a little concerned, and hopefully she's okay. Paid people to be disruptors. You guys, like, honestly, I may not be. There were some content creators who's you, and I've been very vocal. I don't think I've like hid this. Like, I'm not a fan of Tisa Tells. I'm not at all. But I don't think that she deserves to be heckled or attacked or anything like that outside. Like, her opinion may be very different from mine, but I am not a fan of Tisa Tells. I'm not. She Historically, for those that don't know, she when the Shanquella Robinson case was going down, she was taking content from my friend Danny Robertson, and others. We were small, very small creators, right? So like, it's and not crediting the accurate creators for the research. So I'm not a fan. I also think that my opinion is that when she gets something wrong, she doesn't ever correct herself, ever, ever. I've noticed that too. So like, when she said that the prosecutor dropped the charges, the way in which she said that kind of led everybody to believe, oh, it must be true. Had a lot of people between her and TMZ coming into my chat saying different things. I said, yeah, I'm just like, and I've been vocal, but I definitely don't feel like people need to attack her for her opinion. But she does get a lot of things wrong, and she never ever corrects herself. And I think that's the difference between a lot of us, like, what sets people apart. But she has her audience and her supporters that support her, and I mean, that's on them. That's the kind of content that they want. um but I definitely don't agree that people need to go attacking people just because their opinion is different than yours. Like, what? That don't make no sense. I don't attack people for, like, this is crazy to me. Like, I just don't. It's not what we want to do. It's not the kind of society that we want to live in. um my opinion, this is just my opinion. I think that this man should have been found guilty for what happened with Cassie specifically. I'm not so much the Jane Doe, but that's just my opinion. But you know what? That if my opinion doesn't matter, because guess what? It's not about me. It's not about my opinion. It's about how the jury found this man. And they've assessed that this is how it went down. And, I think we have to respect what that verdict was, whether we agree with it or not, whether it's wrong, wrong, wrong marker. Let's do this one. Whether we agree with it or not, we have to trust the process, if that makes sense. So it is what it is. You won't be supporting but yeah, I thought that was a little distasteful. You guys know I like Armand. I do. I don't think that was a good thing to do, my opinion, though. But I think Armand's coverage of this trial was amazing. I thought he did well up until, I don't know, the whole baby oil thing kind of took me out. I was like, I guess I don't understand if that was your sister or your brother in that position making the allegations that they were making. I'm pretty sure people wouldn't be dancing in baby oil, but that's just my opinion on that. It was in poor taste, but as far as the reporting, they did well. As far as the reporting, I thought it was amazing. A lot of content creators, including Armand, including, Mims did amazing too. Shout out to Mims, because he really, he has his professionalism and decorum of him that I thought was amazing. You could tell that Mims really took it upon himself to, even in his voicing of where he stood, that he just had a professional about him. And I really, like, I would love to see him cover more cases with courts and stuff like that. You could tell that he did a phenomenal job. I mean, I thought he did a phenomenal job. There was a lot of others out there that also did a phenomenal job. So shout out to them. I may not agree with the tactic, but I can say that the reporting was phenomenal. And guess what? A lot of people watched. They did. A lot of people watch, whether I like Tisa Tells or not. A lot of people watched her and they support her, and she's earned her place in that. And I think that's amazing for her. I think it's wonderful that she's done that. I may not be a fan of it, but that's just my thought on that. Let me see what you guys are saying. Let's see. Yeah, Mims was amazing. And I saw, if I remember correctly, when Mims was live, BJ kind of made an appearance on Mims video too. So that's why I didn't think that everything was going like, when she said that it got crazy over there, and things got a little out of hand. I didn't even think that anything went down as crazy, but now seeing this, like, maybe people were paid to kind of be agitators or to start shit out there. I'm not really sure, because that courthouse was just crazy. It was a little crazy. Yeah, things went south fast. Well, we kind of knew that that's what was going to happen. Y'all remember we talked a little bit about that. I think earlier on I said, I heard through the grapevine, because I had heard this, a lot of content creators had heard this too, that if he was found, if there was a verdict, that there was going to be a protest out there, depending on what that verdict was going to be. So, like I said, you guys are entitled to your opinion. I'm just here to report the news. That's how I feel. But shout out to all those content creators. I mean, I thought it was a very much an eventful um this whole thing was just interesting to watch. Like, I can't believe we spent 2 months. Whether it's the people in New York who literally spend a lot of money. Nika at Night did amazing too. You guys know I like Nika at Night a lot. Infamous Sylvia, Queen Amadaya. These were just a couple people that I was watching. Who else? Who else? There's a couple. Trying to think. There was a lot of drama out there, of course, because it wouldn't be a YouTube situation if it wasn't for the drama that it follows. There's always drama that follows everything. But I think it was very inspirational to see, certain people get together. And one of my favorite things out of this situation overall is that content creators really came together. Like, I didn't see um a whole lot of like people hating on each other, if that makes sense. I really thought that was cool. I thought that was cool that people came together. I mean, even though I'm not there, I felt like I got shouted out, and that was amazing. I like Ticket TV shouted us out. Shout out to Ticket TV. He wasn't there, but us content creators that we were reporting here, BJ, for example, she started here and then went out there. Inner City Press, of course, we wouldn't be anywhere if it wasn't for Inner City Press, honestly. But it was really cool. Like, it was really cool to see all that. And if it wasn't for some of these creators, BJ, Ticket TV, some of these folks that shouted us out, Mims, we wouldn't be as far as we would are if it wasn't for the fact that we all worked together. We weren't in the same courtroom, but we were all working together to make sure people got the information that they needed, if that makes sense. But yes, yes, yes. Thank you. Thank you, thank you, thank you. I agree, Fashan, on this one. I can disagree and be respectful and address you as the name on your birth certificate. Be kind to each other. You never know what the other persons are going through. You don't. You really don't. And, you know, we just don't know. And everybody's got a little bit of everybody wants an outcome. Everybody's got some vested interest in various things. So yeah. All right, guys. So without further ado, nobody should be bashing BJ. Period. That'll not be tolerated. Thank you, Lady J. And we'll let the mods handle that. Thank you. Thank you for those that are here. Let's get it together, because oh my God, yesterday was eventful. So yesterday we had deliberations, we had a verdict, we had bail, and then we had a press conference. Okay, that makes sense. Hold up. What? Is this for me, Chico? Girl, stop shortchanging yourself. You could hold it down on your own. I like y'all coming together, but you absolutely could hold it down. You know what? That goes into my I think that's for me. I'm pretty sure you're talking about me, Chico, because you totally made that in all caps. I struggle with some imposter syndrome. I forget how well I can handle things. And part of it is because I'm so used to it. Maybe it's because, like, you know, first generation, being the oldest, like that. It's a lot that gets thrown at you. But I appreciate you. Thank you, thank you, thank you, thank you, thank you. And of course, I can't forget that we got shouted out by Coco from SWV. Like, that just, what? The lady watches my channel. Okay. That just took me back to like middle school slow dances. You don't even know. I just couldn't believe it. I'm here for it. So shout out to us, and hopefully I don't know. I just started following her on Instagram. So that was awesome. That was awesome. I telling you, that made my day. I went to bed with a smile on my face on that one. Okay. Let's get it together. Let's get it together. Let's get it together, guys. Make sure you guys are hitting that like button. Thank you. Thank you. Much to review. So we have the transcripts. I'm going to put some timestamps for those that are just watching the replay and you're like, you're talking too much. I know I'm talking too much. But let's get it together. Let me do something real quick. Thank you. Here we go. Where are the transcripts? Right over here. Okay. Shout out to everybody in the chat. So again, this was July 2nd, 2025. Okay. And all the people are present. Now the trial starts, trial resumes. The court. Please be seated. I'll ask the deputy to hand me the note. So if you guys remember, this was early in the morning. We were getting rumors that there was a verdict. Okay. We're sitting over here on my computer. We don't know if it was a note confusion or what's happening, but specifically, the judge wanted to make sure that there was going to be a verdict for all the charges. Okay. The court, please be seated. Please be seated. I'll ask the deputy to hand me the note. The deputy clerk. Yes, Your Honor. The court. All right. We have received a note from the jury at 9:52 a.m. The note reads, "We have reached a verdict on all counts. We'll make this a court exhibit. Anything to address from the parties before we bring out the jury?" Miss Comey. No, Your Honor. The court. Anything from the defense? Agnifilo. No, thank you, Your Honor. Okay. The court says, all right. The only thing that I'll say to you, to those of you who are in the courtroom and in the overflow rooms, is to maintain order while the verdict is being read and until we have the jury out of the courtroom for the sanctity of the process. And there are a few things that we do need to deal with before we adjourn. And so I just ask everyone's cooperation in maintaining order as that is done. With that, I'll ask the deputy to bring back our jury. Okay. The deputy clerk speaks. Yes, Your Honor. The jury is present. The court. Please be seated. Members of the jury, excuse me. Let me slow down. Hold on. I need to get a drink. Hold up. Because this is when everything gets all excited, guys. Members of the jury, we have received your most recent note stating that you have reached a verdict. I will ask the deputy to provide the foreperson with the microphone, and I'll inquire as to the verdict. Juror number 5, the foreperson. Yes, Your Honor. The court. Our foreperson, have you reached a verdict? The foreperson. We have. The court. Is the verdict unanimous? The foreperson. It is. The court. Can you please provide the verdict form to the court deputy? All right. Mr. Deputy, can you please provide the verdict form back to the foreperson? The deputy clerk. Yes, Your Honor. The court speaks. To the foreperson, the deputy will inquire as to the verdict, and then we'll go through each of the jurors to ensure that the verdict is each of your verdicts. Mr. Deputy, you may proceed. Okay. Deputy speaks. Yes, Your Honor. In the matter of the United States versus Sean Combs, 25 CR 542, the verdict sheet, count 1, racketeering conspiracy. Juror number 2, how do you find the defendant? Not guilty or guilty. The foreperson, not guilty. Okay. The deputy clerk, Proceeding to the next count. Count 2, S trafficking of Cassandra Ventura. How do you find the defendant? Not guilty or guilty? Not guilty. The deputy clerk. Count 3, Mann Act, transportation, Cassandra Ventura. How do you find the defendant? Not guilty or guilty? Guilty. You highlight this. The deputy clerk speaks. Count 4, S trafficking of Jane. How do you find the defendant? Not guilty or guilty? Not guilty. The court. Count 5, Mann Act transportation, Jane. How do you find the defendant? Not guilty or guilty? Guilty. The deputy clerk speaks. Your Honor, I will now poll the juries individually. If you could pass the microphone. Juror number 1, is this your true and correct verdict? Yes. The deputy clerk, thank you. You may pass the microphone over. I will ask you as well. Thank you. Juror number 2, is this your true and accurate verdict? Yes. The deputy clerk, thank you. Juror number 3, is this your true and accurate verdict? Yes. Okay. Thank you. Juror number 4, is this your true and accurate verdict? Yes. Okay. Thank you. Juror number 5, is this your true and accurate verdict? Yes. Deputy clerk, thank you. Juror number 6, is this your true and accurate verdict? Yes. The deputy clerk, thank you. If you could pass the mic all the way down, says the deputy clerk. Juror number 7, is this your true and accurate verdict? Juror, yes. The deputy clerk, thank you. Juror number 8, is this your true and correct verdict? Juror answers yes. Thank you. Juror number 9, is this your true and correct verdict? Yes. Okay, thank you. Juror number 10, is this your true and correct verdict? That is correct, says the juror. Thank you. Juror number 11, is this your true and correct verdict? Yes. Okay, thank you. Juror number 12, is this your true and correct verdict? It is. Thank you. The court, the deputy clerk speaks. Thank you. The verdict is unanimous, Your Honor. Court says, very, very good. Counsel, is there any reason that I can now Counsel, is there any reason that I cannot now dismiss the jury? Ms. Comey speaks. No, Your Honor. Mr. Agnifilo? With our thanks, says Agnifilo. Meaning, I may dismiss the jury? Agnifilo says yes. All right. Ladies and gentlemen, in a moment, I'm going to excuse you. Before I do, I want to say a few words about the trial. This is a case that has received considerable press. I can already tell you that members of the press will ask to speak with you. Not only are you free to refuse to speak with anyone or disclose what went on in the jury room, but there is good reason to decline to discuss anything with the press. Our jury system has long been based on the notion that what happens in the jury room stays in the jury room. As the Supreme Court has explained, freedom of debate might be stifled and independence of thought checked if jurors were made to feel that their arguments and ballots were to be freely published to the world. In that regards, I think there's an important reason to respect the privacy of your deliberations. With that said, the choice whether to speak with others about the case and your personal views is up to you. This is your choice. All of the instructions that I gave you previously about not talking to each other about the case, not talking to anyone else about the case, not looking up anything about the case, reading anything about the case, I probably gave you that instruction about 50 to 100 times. All of that is gone. Poof. You are not subject to those instructions anymore. What I will ask is that if you do speak to the press or anyone about the case and your involvement in it, that you respect the privacy of your fellow jurors, deliberations, and views. You can speak about your own views about the case, but do not speak about your colleagues' views, where or how the deliberations played out. I will also ask that members of the media respect this principle by refraining to asking jurors about the deliberations. Jurors, if you have any questions or feel uncomfortable based on any outreach that you receive from anyone, please feel free to bring that to my attention. And in a moment, after we adjourn here, I'll provide you with the court's contact. Okay? Contact information so that all of you can contact the court and have an open channel here. I want to really thank all of you for your hard work, your patience, and your dedication. I know that you've given up a lot to be here for the last for the last over 10 weeks, and it's taken tremendous sacrifice. But I want you to know that it is inspiring to all of us. You listened, you worked together, you were here every day, rain or shine. You did so with no reward other than the reward that comes with answering the call of public service. And that should give all of us hope. So, on behalf of the parties, the court staff, and most of all myself, I want to really thank you for your service here over these past 10 or more weeks. Now, if you're willing to wait, I know that you've been deliberating for a while and you've been here for a very long time. And if you need to leave, then I would totally respect that. But I have a few important matters to address with the parties. After that, I love to come back to the jury room and meet you personally and thank you personally for the hard work that you've put into this case. With that, I will excuse you for a second to the jury room. It may be more than a second, it may be a few minutes, and then I'll be back there. Just give me a few minutes and I'll be back there to meet you personally. With that, all rise for the jury. Jury discharge. Court says, please be seated. Okay, let's stop right here so we can digest. And we are, okay, we're doing pretty good. It's only 43 pages, guys. Shout out to everybody in the chat. Let me shout out some people. Susan P, thank you so much for gifting 5 memberships. Thank you, love. Thank you. Some hearts for you. Thank you. If you've been gifted or blessed, put some hearts in the chat. Daphne, thank you so much for the $2. Thank you for reading the transcripts. No, thank you guys for those that donated, for those that supported everybody, y'all. This is interesting. Thank you. It's been quite the ride. Some of you guys were asking some questions about it. Let's see. Y'all are going in on these comments. Good morning, Sylvia, Pika, everybody come through. Hey, Valerie, Cheeks, I see everybody. Is everybody okay? Hope you guys are doing amazing. Thank you. Just got to drink some coffee. The jury is wild. Look at you guys. This was something else, guys. Definitely. All right. Cool. Let's get it together. So we're gonna keep going. I have some water and my drinks here and some food. Okay. So the court excuses the jury and says, please be seated. I'm not looking at the chat too much, so I apologize if I'm not paying attention. All right. I'll hear any applications, and then we can talk about a sentencing date. Anything from the government? Ms. Comey? No, Your Honor. The court. Anything from the defense? Agnifilo? Yes, Your Honor. In light of the fact that Mr. Combs is no longer charged with S trafficking, which carried a rebutable presumption of detention, or with RICO, and he remains only charged with prostitution, he should be released. He should be released on appropriate conditions. He should be permitted to return to his home at Two Star Island in Florida. We are in possession of his passport. We will provide that to the pretrial services. In light of the charges of which he now stands convicted, every federal crime is serious. And I'm not saying it's not a serious federal crime. It's a crime of a vastly different nature than the racketeering offense that he was charged with, which now he's been acquitted of. It's a crime of a veracity different nature. Excuse me. It's a crime of a vastly different nature than the S trafficking offense of which he's been acquitted. So I believe that a considerable change in his conditions is warranted. I know that, and I believe that his plane has been charted. It's in Maui. We found out this morning in the eventuality that this came to pass. I knew I'd be making a bail application. So he does not have access to his plane. He will absolutely, and this is his first conviction, and it's a prostitution offense. Now, so he should be released on appropriate conditions. His entire family is here. Any one of them, any three of them, any five of them can sign on to a bond. So it would make sense if Your Honor was considering release conditions, and I do hope Your Honor does. I do this while we have this entire family here physically together. And so my proposal would be that he be released today. He be permitted to live at his home in Florida. The address has been in the record. So I'm not giving anything away at Two Star Island. It would be a bond of whatever size Your Honor sees fit. I mean, for a prostitution offense, maybe $1 million. It could be co-signed by different members of his family who are here, and that is our application, Your Honor. The court speaks. Well, let me just make sure, because obviously this is just coming up right now, and you have not had a chance to address this with the government. And I will obviously hear from the government in a moment. Is your proposal that Mr. Combs leave this courtroom and walk outside? Agnifilo speaks. Whatever. The court speaks. I'm just asking about the mechanics of this. Agnifilo speaks. That is Mark Agnifilo's proposal. Yes. That is my proposal. I know that there are things that our marshal services has to do, but that is my proposal. Yes, that he has been acquitted of a very, very serious charge. He's been convicted of a far less serious charge, both in terms of its guidelines, exposure, and its maximum sentence. And in light of that, it is my proposal that he be permitted to walk out of the courtroom. The court speaks. Okay, just for the mechanics. And then in terms of your application, it is for $1 million bond. Agnifilo speaks. $1 million bond. The court. Secured by 3 financial responsible persons. Agnifilo speaks. Correct. The court. And Mr. Combs has already relinquished his passport. Agnifilo speaks. We have physical possession of his passport, and we'll give it to the pretrial services. The court. Any travel restrictions limited to Florida and New York? Agnifilo. Florida and New York, Florida, Los Angeles, and New York. Court says, all right. Any response from the government? Comey speaks. Yes, Your Honor. The government opposes this application. The application statute is Title 18 United States Code Section 3143A1, which provides that a person who has been found guilty of an offense and who is awaiting imposition of execution of a sentence shall be detained unless a judicial officer finds by clear and convincing evidence that the person is not likely to flee or pose a danger to the safety of any other person or the community if released. In other words, the burden is now on the defendant to demonstrate by clear and convincing evidence that he is neither a flight risk nor a danger. Mr. Agnifilo tries to downplay the seriousness of the 2 counts for which he was convicted, but the facts state otherwise. They reflect years-long conduct that involve not just the hiring of escorts, but also physical abuse. That, Your Honor, heard extensive evidence about that the defense did not contest, and that also involved the prolific use and distribution of rugs, which Your Honor also heard extensive evidence about, and which the defendant did not contest. We intend to seek a sentence of incarceration. The guidelines will provide for a sentence of incarceration. The maximum sentence the defendant faces is 20 years in prison under the 2 statutes of which he has been convicted now. Your Honor has also heard that while the defendant was under investigation for this very case, he continued to commit a litany of crimes, suggesting that he does not have respect for the law, and suggesting that even when his attorneys, I'm sure, advised him to be following the letter of the law, and when he knew he was under careful scrutiny and very close scrutiny from the federal government, he was not deterred from committing additional crimes, including the vicious assault of Jay that Your Honor heard detailed evidence about, and the provision of rugs and the hiring of escorts. Indeed, when the defendant was there in New York City, according to Mr. Agnifilo, waiting to surrender to federal authorities, he had rugs in his hotel room. He had all of the supplies to commit this very same crime once again. There is no reason to believe, not to mention clear and convincing evidence to suggest, that he will do anything different if he is released now. Given all the evidence Your Honor has heard during this trial, it is clear that the defendant does pose a danger, and that there is a real risk that he will flagrantly disregard orders from this court, that he will commit new crimes, and that he will attempt to flee from justice. For all of the reasons that Your Honor heard from the rest of my team during the various bail applications early on, so even with not guilty verdicts on 3 of the charges here, the convictions here, and the standards here under the statute suggest that Your Honor should be detaining this defendant until sentencing. Okay? Let's take a drink of water out of that. Oh my God. What do you guys think so far? Oh my goodness. Nurse Janice, thank you so much for being a member for 6 months. Rabbit, you're truly amazing. Thank you for your dedication and professionalism. You always are real and make us laugh. Shout out to you, Nurse Janice from the UK. Thank you. Thank you. All my beautiful people from the UK, the UKians. Shout out to the UKians. Comey was like, I would have loved to have been in the courtroom to have heard the passion in her voice. The passion in her voice. Hey, Franny Law, the inflection, the all of it. I would have loved it. Would have loved it all. Okay. Let's keep going, because Agnifilo has to respond. Okay. Okay. Where's my paper? Here it is. Okay. Agnifilo speaks. Your Honor, if I could be heard. Court says, well, hold on. Yes. Okay. Court speaks. Ms. Comey, do you have any, and this is a big ask, because this is just coming up right now, and I'll tell the parties that I'm not going to resolve this in this second. We're going to resolve it while everyone is here, but I need to look at the applicable statute and consider the views of the parties to make sure that we're making the right call here. With that, Ms. Comey, do you have an example? Is there another situation in which there's either been a pretrial detention based solely on a Mann Act violation, or based on a conviction on a Mann Act charge? Bail was denied on those grounds. it's a question that is fair for me to ask you under under these circumstances. And I'm happy to give you the opportunity to confer with your colleagues. Do what you need to do to get that information and come back, because we're all here. We all plan to be here for the whole day. And I want to make sure that I heard your arguments and make sure that I get this right. Miss Comey speaks. Yes, Your Honor. I don't have an example off the top of my head of a Mann Act charge based on the transportation of adults. I can think of instances where the Mann Act charge involved the transportation of minors. I cannot think of an instance of transportation of adults. I will note, however, Your Honor, that we do intend to ask Your Honor to consider relevant conduct when crafting this sentence. And I think it will be entirely appropriate for Your Honor to consider relevant conduct, even setting aside acquitted conduct. The violence and the rug use that surrendered these violations are relevant conduct that Your Honor will be asked to and should consider when imposing sentence in this case. And that is why I think that we will be seeking a substantial period of incarceration, even setting aside whether or not Your Honor considers acquitted conduct. That's why this case is very serious. And even with the conviction on just 2 charges, there is serious, relevant conduct here that will merit a lengthy period of incarceration. The court speaks. And Mr. Agnifilo, I will hear your oral application. Agnifilo says yes. The court. But what I'm thinking is that we are here, and I think it would be helpful to me at least to receive even a letter from each side of these issues. How much time, Ms. Comey, would you need to put together a letter describing the further details, the statements that you've made, and the applicable law? It's 10:30 right now. Comey speaks. Your Honor, if we could have a few hours, that would be helpful in order to run the guidelines, in order to do a little more research on the question that Your Honor asked me about. If we could have a few hours, that would be helpful in order to provide a letter to Your Honor. The court. I think that makes sense, Mr. Agnifilo, and I understand that you don't, that Mr. Combs does not want to go back to MDC. All right? He's shaking his head. So Diddy was shaking his head. Hold up, I got a cough. When the court was speaking to Agnifilo, he says right here, all right, he's shaking his head because he's like, I don't want to go back to MDC. Court continues speaking. So look, what it's going to mean is that you're going to have you're going to have to cool your heels in the courthouse for a while. But I think that makes sense again, to just make sure that we get this right. So 1 p.m. could each side put in a letter on their positions on the issues of bail, and then I will consider it, and we will reconvene later in the afternoon. Agnifilo speaks. That's fine, Judge. Thank you. The court. Okay, very good. And Mr. Agnifilo, I didn't want to cut you off if there's something you wanted to say in response to Ms. Comey. Agnifilo says, I have plenty to say in light of the acquittal and all the things he's been acquitted of, most of which has been now mentioned by the prosecutor. But we'll put all this in a letter. The court says, all right, very good. So we'll adjourn here until we'll adjourn here and we'll notify the parties and we'll let you know when we're going to come back, but we'll await the party submissions at 1. With that, anything further from the government at this time? Comey, no, Your Honor, not at this time. Okay, the court. Anything from the defense? Agnifilo speaks. Just one last thing. We'll put this in the letter too. Mr. Combs has been given his life by this jury. He was charged with counts that could have given him life in prison. He's going to get far less than that. He's going to have his life. He would be nothing short of a fool, which he is not, to do anything that would violate any conditions that this court set when this court releases him. And I hope it does. This is a unique set of circumstances. This man was looking at spending the rest of his life in prison if he was convicted of the S trafficking offense or the RICO offense with the racketeering activity that was part of it. He's been acquitted of that conduct. He has every reason to believe that Your Honor will sentence as Your Honor's done everything in this case with fairness and circumvention. Hold on. I want to make sure I said this right. Is it circumspection? Thank you. Thank you, Google. Okay. He treasures, I assure you, the opportunity that he has been given, and he will not run afoul of anything that this court imposes on him. That's the last thing I want to say. We'll submit our letter by 1:00. Court says, all right, very good. Court speaks. For everyone who's in the courtroom, the only thing that I will say is please follow the instructions of the court security, because we do not have jurors in the back, and they may have some instructions for you in terms of filling out of the court room, given that the jurors are still here. With that, we will adjourn and we'll await the parties' submissions. Okay, perfect. So this is when they wait. They tell us we'll be back at 1, but they don't actually get back until what? 5, right? Where are we at? Okay, we're doing good timing. Page 20. Shout out to everybody. Let's see. Judge Wood, thank you so much for the $2. The judge denied bail for violence in an 8-year-old tape. Well, I mean, that's what the judge decided to do. What do you guys think? Let me know in the chat. I don't think any opinion is wrong. I have people that are kind of divided. I have people that feel like he should have been released. Now we're not even going on the RICO. We're literally talking about the bail part, right? People, I have people in my chat that believe that that he shouldn't have been convicted. And then I have people in my chat that believe that he should have been convicted. I'm literally just reading the transcripts. I want to know what you guys think in the comments, as long as we keep it cute and respectful. But let me know what you guys think in the comments. Let me see before I start reading the others. Welcome, everybody. You're late, Moni. You're late. Okay. So now he's waiting for his sentencing. Do they now move him to a prison? Because I doubt he's going to stay in New York till October. Well, that's a good question. Does he get moved to does he stay at MDC till October? I think because isn't a move, wouldn't that be on the record too? So I know that they have I think it's like a status conference on July 8th, but the actual sentencing hearing is not until October 3rd. That's when we know that's happening. But I do wonder what I wonder how that's going to go down. See, legal experts in this area of law think that he will get 3 to 5 years. I heard the same thing too, with credit time served, but I don't know. I think the judge can stack 21 months on the first with no priors and 8 to 10 on the second with no priors. It's literally up to the discretion of the judge at this point. So he better, I'm telling you guys, the jury might have found the RICO not guilty, but he doesn't mean that the judge can't use that against him during the sentencing. Which is what happened. This is where I think the defense might have shot themselves in the foot a little bit. Yes, they owned up to the DV. Okay. They owned up to that. Yes, they owned up, but they never really refuted any of the violent acts, when that's been said, when Capricorn Clark said what she said, right? You didn't hear what they did is that they tried to discredit Capricorn Clark by saying, well, you still wanted to work with him. You still wanted to do this. The defense could have done a different tactic, in my opinion, because guess what the judge did? And we kind of learned this. I haven't read the Sting part yet, so I'm curious to know what his thought process is. But he used the defense's own words, to basically say, you're not getting bail today. So there could have been a different tactic if they could have applied something different if they were working on a release. It's something in the opening statement and in the closing statement, because Tini Garagos said, yeah, this is what happened. We're not disputing that. But you have to kind of wonder, okay? Like when he was facing all of this, and I'm no fan of Jane, please note that. I'm not anything like that. But when the situation happened, when shit got off the hand, what is it, in June 2024, I have to wonder, like, why didn't he, if you knew, if the argument for Diddy, which was the defense's argument, Jane Doe knew that he was facing all this stuff, and then that's when she gets violent. That's when things get physical between the two of them. Okay. Well, why? Why didn't Diddy walk away? Why didn't Diddy say, well, fuck, I'm fighting for my life? She could be trying to set me up for me to go in there for years and years. Like, at some point, you kind of have to wonder, who takes that? Because she could be wilding out right there, hitting him, which is what the defense said. She got physical. Well, why didn't he walk away? What if I'm fighting for my life and I got this thing holding over my head while they're investigating me? You better believe that I'm not going to be breaking the law while they're investigating me, or give anybody room to say, oh, you did this to me while you were under this federal investigation. That shit makes no sense to me, guys. It doesn't. So the defense can throw that in there, but what do they do to refute that? What do they do to refute that? Well, that's her fault that she got physical. Even if that's the case, even if she hit him first, guys, it doesn't, like, you're the one under federal investigation. No discipline right here. And not, like, it doesn't make sense. And so then it does leave the room for people to say, well, damn, like, does he think he's above the law because of the fact that, you're willing to put your hands on this girl? You're wanting to get out now. But the defense could have done a better job right there, if that makes sense, in my opinion. But okay. No, he doesn't have. And what a perfect time. What a perfect time to have said, you know what? If they're going to use the defense of, well, she got physical first. Well, what did Diddy do to address some of this, like, impulsive outburst that he has that's been described? They said it in there. Well, he was going to batterers, or he was trying to get into a batterers program. Why didn't he do that before? Hell, he could have paid for a counselor to come to his house to give him counseling on this, so that if he knew that this shit was coming down the pike, he could have started working on it. Like, I don't get it, but that's just my thought on that. At the end of the day, like, he's the one sitting there. So if people were, trying to set him up, as the defense was saying, you don't put yourself in that situation. This is not a child, guys. But that's just my thought. That's my opinion. Let me know what you guys think in the comments. Okay. Y'all have to drink. Okay. He should have went to therapy before the shit hit the fan. You know what I mean? Thank you for saying this. That's all. Like, and then the defense could have said, you know what? He's addressing this issue. He has this impulsive control situation, if you know what I mean. You said walk away from the female, ramming your head into the. He could have, Judge Wood. What? So what would be, if he's the one facing he's the one facing those charges, right? She could have been physical. She could have came after him with the knife. But the end of the day, it's the bigger picture is he's the one with the charges, not her. She's not the one with the charges. He is. So in a situation like that, oh, fuck it. Like, okay, you ran me through a great, you can't defend yourself, guys. You can't do anything. Hey, get out of there. Don't even come back. Don't even, just move away from that situation. That's what you have to do. That's just my opinion on that, but you guys are entitled to yours, okay? All right. Let's see. He never enrolled. No, he didn't. I don't know. Okay. Let me know what you guys think in the comments. The case is over. Stop trying to make a new case. I can't make a new case because I'm not a judge or a jury. Do me a favor and go find yourself. Thank you. Okay, let's keep going. Welcome, welcome, welcome. Afternoon session at 5:15 p.m. Okay, the court says, please be seated. All right. The law, y'all are laughing in the chat. Let's keep, I'm like, yeah, I can't make a new case. Go find yourself. Go find a hobby. Go do something. Go water plants or something. Okay. I have received the parties' submissions as well as the submissions from various third parties that have been filed today. Filed today. Hold up, I gotta drink some water. I can't even read. Okay. So I'm telling you, man, people come trolling at me. Go find a hobby. Go find yourself. Go do something with yourself. Okay. Court says 5:15 p.m. afternoon session. Here we go. Court says, please be seated. I've received the party submission as well as the submission from various third parties that have been filed today. Okay. Thank you for those. All right. The jury in this case convicted the defendant on counts 3 and 5, each of which charged him with knowingly transporting any individual in interstate or foreign commerce with intent that such individual engage in prostitution in violation of 18 USC section 2421. Count 3 charged the defendant with violations with respects to Cassandra Ventura, and count 5 with respects to Jay. Following the verdict, the defendant moved for bail. For the following reasons, bail is denied. Lord have mercy. He said it right in the first sentences, guys. Remember, we were shocked. We're like, well, that was quick. Bail is denied. He just said it. Okay. While the defense's letters proceed under the assumption that 18 USC section 3143A1 applies, the government correctly notes that section 3143A2 is the applicable provision, which makes the detention mandatory absent circumstances not applicable here. There is a limited safety value for mandatory detention under 18 USC section 3143C. However, it requires that the defendant, in addition to proving by clear and convincing evidence that he poses no risk of flight or a danger to any person in the community, clearly shows that there are exceptional reasons why such person's detention would not be appropriate. The Second Circuit has made clear that exceptional circumstances exist where there is a unique combination of circumstances giving rise to the situation that are out of the ordinary. United States versus Leah, the Second Circuit in Leah cited to the United States in Lepole, which collected cases have noted that circumstances that are purely personal do not typically rise to the level of exceptional warranting release. But those are precisely the types of circumstances that the defense points to in their second submission from today. For that reason, those that follow, and in the government submissions, the limited exception to mandatory detention has not been demonstrated. The court disagrees with the defense's argument that the crime of conviction here does not trigger the mandatory detention statute. It plainly does on the face of section 3156A4, which includes in the definition of crime of violence any felony under chapter 117. There is no dispute that the crimes of conviction here arise under chapter 117. The court rejects the defense's invitation to override the plain text of a congressional statute based on legislative history. And there is no ambiguity that would permit the court to rule in the defense's favor on lengthy grounds either. But even if the defendant was solely required to demonstrate by clear and convincing evidence that he is not likely to pose a danger to the safety of other person or the community, under section 3143A, he could not meet that burden for the following reasons, as well as those articulated by the government in their submission. The court first notes that prior to trial, when detention was not mandatory and the burden was with the government rather than defense, the court denied bail. And the court sees no reason to reach the opposed conclusion now, the opposite conclusion now, excuse me, where the burden is with the defendant and by clear and convincing standard, no less. Then we move to the trial in this case. At trial, the defense conceded the defendant's violence in his personal relationship, saying it happened with respects to Cassie Ventura and Jane. Okay. TR 7759, lines 18 through 19. We own the domestic violence. We own it. Didn't I tell you guys? Opening statement. Let me stop right here. Tini Garrigo said in her opening statement, okay, we own the DV. We own it. Because this is how the labeling of the case happened, right? It further goes. TR 7760, line 11 through 12. We own it. They use the defense's closing and opening statement to base that. That's what the judge did. He used their statement to basically make its decision. Okay. It further goes. Lines 14 through 16. If he was charged with domestic violence, we wouldn't all be here having a trial because he would have pled guilty because he did that. Right? The defendant's concession was unnecessary because the defendant's violence was starkly depicted in the 2016 video of the Intercontinental Hotel incident involving Cassie Ventura. Here's what defense counsel said about the video in his closing arguments. And I quote, imagine what that's like, because it's horrible. It's just, we're going to be real today. That's horrible for Miss Ventura and her parents. This video comes out all over the world, and there it is. It's a terrible moment. It's a terrible moment. And she could have said anything. I'm glad she said something. But what she said rings true, not only for her, but for this trial. And I most respectfully submit for all of you, domestic violence is the issue, is what she said. Okay. The judge is quoting the defense here. Okay. TR 7285. The video is very much domestic violence. And that wasn't the incident only of violence that the defense referenced. TR 7795, lines 2 through 4, referring to the London hotel incident. Obviously, something happened. Obviously, there was some physical event and she had injuries. Okay. And later at TR 7860, line 5, he was violent at times. The judge continues. This type of violence, which happens behind closed doors, is in personal relationships sparked by unpredictable bouts of anger, is impossible to police with conditions. Having conceded the defendant's propensity for violence in this way, it is impossible for the defendant to demonstrate by clear and convincing evidence that he poses no danger to any other persons or the community. So there you go. Let me stop right here. Do you want this is right here? This is what I was telling you guys. And the guy that I had to block because he thought he was cute. When he said, what did he say? He was using the lines specifically from the defense, outlining the Intercontinental Hotel, the London, to outline specific events of violence. He used the defendant's own words to basically say why he wouldn't grant Diddy bail. That's what they did.
I'm not making a case for Diddy. Or against Diddy. I'm literally reading to you exactly what the transcript said. He just said it right there. This type of violence, which happens behind closed doors in personal relationships, is what the judge says, sparked by unpredictable bouts of anger, is impossible to police with conditions. If you're released on bail, what do you need? Conditions, my friends. What if you're on bail? What do you need? Conditions. He's saying right here, we cannot police you if we don't have these like because of these bouts of anger that you've had based on what the defense has presented. Okay? There you go. I'm just reading what the judge said, okay? All right. Let's keep going, okay? It is impossible for the defendant to demonstrate by clear and convincing evidence that he posed no danger to any other persons or the community. Notably, the judge continues. I know, how dare you, Rabbit, read the actual transcripts? I don't know. How dare I? Okay. Notably, evidence of the defendant's violence includes conduct that occurred after the searches involved in this case had taken place and when the defendant was aware that he was under investigation of S trafficking allegations. One of the government's most striking examples of violence against Jade, as to which there was visible evidence of bruises and injuries, came from June 2024, after the searches of Combs' residence, and at a time when he should have known that he needed to stay clean. This was also one of the alleged violations of the Mann Act that the defendant was convicted on, contrary to the defense's suggestion that even before this his offer of self-surrender, Mr. Combs demonstrated a pattern of trustworthiness and cooperation. DKT 432-2. Okay. This highlights a disregard for the rule of the law and the propensity for violence. The government's letter points to other examples of illegality that occurred after the defendant was aware of this investigation. As the government observes, there was evidence at trial that the defendant engaged in years-long pattern of abuse and violence, including as recently as in June of 2024. And that this and other conduct documented in the government's letter shows that a defendant continues to be a danger to others and is either unable or unwilling to follow the law. Okay. That's from the government's submission. Now, the court takes no position on what evidence or conduct will be relevant to the defendant's sentence on the crimes of conviction. But for present purposes, the defendant is unable to meet his burden to show by clear and convincing evidence the lack of danger to any other person or the community, given the evidence admitted at trial. He certainly is not able to show exceptional circumstances warranting a departure by this court for the mandatory detention that the Congress has required. Under these circumstances, it is impossible for the defendant to show by clear and convincing evidence that he poses no danger to any person, let alone exceptional circumstances warranting a departure from mandatory detention. The court imitates no view as to what the appropriate sentence is in this case. No pre-sentence report has been prepared. The defendant has not been interviewed by probation, and the parties and any alleged victim have not had the chance to put in their submissions on that score. But to put things in perspective, the defense offers that the guideline sentence application to the defendant's offenses of conviction is 21 to 27 months of imprisonment. DK 432-2. The government submits that the correct calculation pins the defendant's guidelines range at least at 51 to 63 months of imprisonment. DKT 433-4. To date, the defendant has served 10 months in prison, time that he will receive credit for on an ultimate sentence in this case. The sentencing will take place in short order. The court proposes a sentencing date of Friday, October 3rd, 2025 at 10 a.m. The court is willing to expedite that date if the defense wishes. In accordance with my individual rules and practices, the defense submissions are due 2 weeks prior to sentencing. The government submissions are due 1 week prior to sentencing. I will direct the government to provide this statement of the offense to probation within 7 days, and defense counsel must range from the defendant to be interviewed within the next 2 weeks. As for any post-trial motions, the defense should follow the deadline under the rule. If the parties agreed upon any alternate briefing schedule, then the court will entertain that request. With that, anything further from the government? The government speaks. Comey, no, Your Honor. Anything further from the defense? Agnifilo speaks. Yes, Your Honor. Okay, let me get a drink of water, y'all, before I start with Agnifilo, because he goes on and on. What do you guys think in the chat? Let me know. Let me know. Let me know. You said, I truly believe that the jurors were compromised. There was a juror with a language barrier. Also, in a few minutes, they deliberated after they were totally in agreement. I remember when the jury selection happened, because we were into that, there was a juror in there with a they were asked to, I don't know if they were kept in the jury. So I don't know if that's a fact. But what I do know is that one of the questions or one of the concerns was for a language barrier. So you might not be too off on that. I just don't know if that person actually stayed in the jury. Other than the low profiles that we have, we don't know their names, guys. We don't know their names at all. But that's my thought on that. But I mean, what do you guys think about the judge's reasoning? So they and like I was it hold up, let me see. Judge Wood said judge denied bail for violence in 8-year-old tape. Because that's in evidence, the judge can use that. That's the thing about once the conviction happens, he won't be getting life or anything like that. He's not charged with RICO, right? Like the judge can't go back and override what the jury said or anything like that. But he can definitely use the evidence to make determinations about what bail is going to look like, if that makes sense. So he can do that. He can do that. And the thing is like, I kind of wonder if the defense could have done something different here to if that's what they wanted to do. You know what I mean? Like he owned the DV. Okay, so what did he do for his DV? In DV courses so far, before all of this went down, he is addressing X, Y, and Z. That didn't happen. But that's my thought on that. You know, he could have been preventative. This is what I made the example of the Jane Doe situation. Yeah, she struck him first. Sounds like she pushed him. Sounds like she should have been, in trouble for that too, because that's not okay, right? But at the same time, the last thing you want to do is have the other person who's the one under investigation engage in that. You don't want that, right? So if I'm under federal investigation and a person's attacking me, I am not going to go back and attack the person, even if it's self-defense. I'm sorry. I'm the one going to court. I'm the one on trial. She's not. Did she know that? Maybe. I don't know. But it does kind of make you wonder. And with that being said, it puts the ownership back on Diddy. Like, okay. It does. So Danielle, do you think that would have made a difference for him to have been released? He should have offered $1 billion instead of $1 million. Do you think that would have made a difference? The man is on a hole for a lot of these attorneys and lawyers, guys. So there's that. I feel like this is being such a high profile case that from day one, after they've chosen the jury, they should have been put in a hotel because of what happened. I do believe, Sylvia, they should have been sequestered. This jury should have been sequestered from day one. Because whatever side you land on, whether you believe this man is guilty or wherever you land, I feel like there was just too many jury issues, if that makes sense. This jury should have been sequestered, if you know what I mean. But There was a lot of money that's been spent on this. And I'm sure, and I bet you that the government is not happy about losing that first count, which carried the most weight. I bet you anything. But they should have sequestered this jury from the very first start. Honestly, it really would have. I think it said yes. I think it would have made a little difference, but maybe not, because I could be wrong. I think a lot of us, the thing about my channel is that none of us know anything. As far as we don't know what it looked like. What I do feel like I have I'll say I have a bias with TMZ specifically, because, and a lot of you guys were asking me in the chat, why are we watching TMZ? Because I need to watch how they're moving while they're reporting in this trial. There have been people that have been making a lot of allegations about TMZ and their insertion into this trial. Hell, even some bloggers. I heard that there was a blogger that was paid by the prosecution. I'm like, where are you guys getting this information? Like, how do you guys know this? People have been saying different things. So yeah, I would have been down for the jury to have been sequestered. Matter of fact, let's do a poll. Why don't we do that now? Should the jury been sequestered? Because then we would have been like, then people couldn't have said, well, somebody got to the jury, people got paid off. We would have like avoided that on the Diddy trial. Okay, let me say this. I'm going to put a third option, not sure. Don't know if it would have made a difference. We're going to put not sure. I guess it's a long word. Okay. Go vote and hit the like button, guys. Can we get to 500 likes, please? And thank you. I'd appreciate it. Let me know what you guys think in the comments. I know, right? See, 90. See, I'm seeing the poll going up here a little bit. Okay. Let's keep reading, guys. Let's keep reading. Okay. All right. Agniflo speaks. Hold up. Let me set everything up. Get all these junk emails. Okay. Agnifilo. Yes, Your Honor. We would like an expedited sentencing schedule. We would like a sentencing as soon as we can get a sentencing and have the court feel that it has what it needs to sentence Mr. Combs. I don't know what the court is in a position to do in terms of expediting that schedule, but we would like as expedited a schedule as we can possibly have. Lord have mercy. He repeated himself. The court speaks. That's fine with me. Now, as you probably have experience with, the difficulty is in making sure that we can have a pre-sentence report, that you have the chance to propose any changes, make appropriate objections. That takes some amount of time. However, I'll turn to Ms. Comey, hopefully for some assistance in this regard. Under these circumstances, where an expedited sentencing is requested, in my experience, the parties have usually met and conferred and then worked with probation to work out a schedule. And I will tell you that I will make myself available on any schedule that the defense requests. I just want to make I wanted to put those cards on the table because I understand that it's really not. I could tell you that we could do this tomorrow, but that's not going to be feasible. So it's really something to be worked out with probation and with the government. Okay. Agnifilo speaks. If the court was open, we'd be willing to waive a pre-sentence investigation report. If the court was comfortable proceeding that way, we'd be willing to waive it. The court speaks. Well, I need the right information to make that decision here. And here's what I'll say. The one thing that I did see is that there is a great divide between the parties' views, even as to the basic questions as to how the sentencing guidelines apply here. And so this is not one of those cases where there's agreement on basically everything. And the only question is how the 3553A factors applies. As reflected in the government submissions, there is a substantial dispute on that issue. I also would want to refer to the various provisions regarding sentencing to make sure that we are acting consistently with the federal rules of criminal procedures and the requirements in that regard. And I see Miss Comey has her statute book open. So she's probably about to tell me that there are certain requirements that would require some amount of time here. Miss Comey speaks. That's right, Your Honor. I'm looking at Rule 36C1, which requires an investigation unless Your Honor um, makes a finding that the court has sufficient information in the record enabling the court to meaningfully exercise its sentencing authority under 18 USC USC 1353, and the court explains that finding on the record. I agree with Your Honor, given the complexity of this trial and the wide divide between the parties, I don't know that the court would be able to make that finding. I will note, though, that in my experience, probation is often able to speed up the process quite a bit. And I'm happy to work with Mr. Agnifilo to contact the probation department as quickly as possible and try to find out how quickly they could finalize a report. The court speaks. All right, let me ask, given that the court is closed tomorrow, what I will ask the parties to do is meet and confer, speak with probation, and provide the court with the status update by Tuesday, which is July 8th at noon. Okay, let me stop right here. So when that date got thrown out this July, this is not a court hearing, guys. So for those that were confused, there's court on July 8th. No, the court says, all right, let me ask, given the court is closed tomorrow, what I'll ask the parties to do is to meet and confer, speak with probation, provide the court with the status update on Tuesday, July, which is July 8th at noon. So it's not a court hearing, it's I wouldn't even say it's a status conference. It sounds like it's just a update to the court. Okay, which is July 8th because they're trying to get probation on. And why don't we set a remote hearing for the afternoon? Okay, followed by maybe a hearing, a remote, but not like everybody comes in. It sounds like there might be a link to this. Yeah, just letting everybody know. Okay. And I'll see what the parties have proposed and I'll figure out a schedule. Does that make sense? So they're going to have, sounds like a remote hearing, but not like it might be, is it like a virtual hearing? That's right. That's right. Like a virtual, but not like everybody go to the courtroom and get to this hearing. And it sounds like maybe like a update on probation, kind of like that. But let me know what you guys think in the comments. That makes sense? Okay. Thank you. And I think time is of the essence. I know it is because you just told me it was, Mr. Agnifilo, and so we'll have a hearing in the afternoon. Okay. I think we can do it remotely unless someone tells me that we need to do it in person to work out the schedule here. Agnifilo speaks. One of the reasons why I'm proposing it in this case is because Your Honor sat through the trial. I mean, I think Your Honor knows what it's like to sentence a case where the court did not sit through a trial, and then when it does sit through a trial, there's just so much that the court knows that as good as the probation reports always are in this district and every district, Your Honor has a wealth of information that only sitting through a lengthy trial could provide. If that were not, I would never suggest this were a trial judge who did not sit through the trial. So I just wanted to make Your Honor understand why I thought this was even a possibility and something that I was proposing. And just very quickly, I understand that there's a divide between parties. The reason that we want the sentence as soon as possible is a very quick review over the course of the day of other Mann Act cases indicates there's nothing remotely similar to this. And why I mean by similar to this is every Mann Act case that we have found involves someone who's making money through prostitution, basically in the position of being a pimp. Very often, these are in the millions of dollars. Very often, these cases where minors are involved, which this case does not have. And so, one of the reasons we want to get this case to sentencing as soon as possible is we think we have very strong arguments that Mr. Combs would be entitled to under 3553A factors to a below guideline sentencing. And so we believe we have strong arguments. Your Honor has made up your Honor has made up your Honor's mind on the subject of bail today. I see that. And as much as I've been preparing the entire day to speak to the court, I don't know as I'm just not seeing a glimmer of light coming from the court. But I would point out one thing because I have been preparing all day. I think the exceptional circumstances are not primarily related to the family. That is what we wrote. And that's what we wrote because we'd been living with the current situation at the point for a total of about 3.5 hours. But I think really what's different about this case is the facts. And the facts makes this so drastically different. We cite 4 cases in the first letter to the court, and the first one was US versus Dillon. US versus Dillon involves a pimp. The pimp had a female adult prostitute that he was basically making money from. And he made over 1.4 million from being a pimp in the prostitution business. He pled guilty and he was out pending sentencing. The same provisions would have applied to Mr. Dillon as applied here. Yet he was out pending sentencing. US versus Daskell was an Eastern District case before Judge. I'm not going to say the judge's name. Mr. Daskell was charged with the Mann Act and other offenses. Mr. Daskell had a long relationship with an underage girl, and he was a grown man, and he was out after his guilty plea pending sentencing. US versus Lynn involved a massage parlor that was, in essence, an prostitution ring. That person got a year and a day. The government recommended 24 months. That person made over 1.3 million from the business of prostitution. United States versus Brenner, which is the last of the 4 cases we cited in our letter, involves something called the Emperor's Club. And the Emperor's Club was noteworthy because the most noteworthy person who used the Emperor's Club service was the sitting governor of the was the sitting governor of the state of New York at that time. Oh, wow. Some of these, I'm telling you, let me time out here. Some of these senators, governors, people are the most corrupt. Okay? They are. Did you just see that, Marsha P? Said the most noteworthy person who used the Emperor's Club service was the sitting governor of the state of New York that time. Cannot make this up, man. Okay, that's the case that Agnifilo is citing. Further goes. The sitting governor was the person using the prostitution service, just as Mr. Combs in this case was the person using the prostitution service. The Southern District of New York did not charge the sitting governor. He was doing these things while the sitting governor he was doing these things while the sitting governor, and because he was the user of prostitution services rather than running the business of making money from the business of prostitution. He was not even charged, as we all know, and I think we all know what I'm talking about. It was in 2008. He resigned, being sitting he resigned as being the sitting governor of New York after the indictment of the Emperor's Club came down. So, all to say, I think we have a very strong argument for a reasonable sentence in this case. So, we're going to move everything we can to try to get Mr. Combs sentenced as soon as possible. I'm looking at Your Honor's face to see if there's a glimmer of light, and I see a smile. What? Agnifalo's like, I'm looking at you, Your Honor. I want to, like, I see a smile, a glimmer of hope. Oh my God. Sorry, it's my first time reading this. I didn't know he said all this. Inner City Press didn't say that at all. Sorry, y'all. I mean, he's defending his client, guys. Like, if I'm gonna say this, if I was Diddy, I would want somebody like Agnifalo or any of these people to help out. They're looking for a glimmer of hope. Okay. Marsha's like, I would seriously sanction Agnifalo for that. No, he's defending his client, y'all. We need a defense attorney. Listen, people want to shit on defense attorneys until you need one. Let's be real, okay? If I was Ziddy, I'd be doing the same. All right, I'm just being real. I'm not gonna be fake about it, okay? um, let's keep going. All right, let's keep going. The court speaks. I do appreciate the summary because I think you're explaining why this case presents perhaps a unique circumstances that would warrant a very expedited sentencing proceedings from your perspective. Agnifalo speaks, but unique and maybe even exceptional. Maybe even exceptional, the court. On that score, you mentioned 4 cases, and I'll certainly give the government a chance to respond. But you're not suggesting that in those 4 cases, the court evaluated the safety valve under 3145, because on my reading of those cases, what happened was that after conviction, whether by guilty plea or by trial, there was simply no discussion of the issue of detention from that point. It wasn't opposed by the government. And so that issue just didn't come up. Agnifalo speaks. That's exactly right. The court. There wasn't an inquiry as to whether there was an exceptional circumstances that would fit the Leia definition. And of course, in Leia, the court revised a district court determination that the exceptional circumstances has been satisfied. Every case presents its own circumstances. In that case, it was, I believe, employment and the fact that the individual was a first-time offender and certain other personal circumstances. That's what gave rise to what Leia said about the nature of the exceptional circumstances. Exception. Agnifalo speaks. I knew the court was going to be concerned with the Leia case, and of course it is. It's a Second Circuit case that cabins what exceptional circumstances can be. But I think we not only have exceptional circumstances, I think we have a unique circumstance. I just don't know of another case where the user of prostitution services has been convicted and moving to sentence on the Mann Act. It's always a business. The Emperor's Club was a business that made a tremendous amount of money from the business of adult prostitution. The other cases are businesses that made a tremendous amount of money from the businesses of adult prostitution. We have a conviction on the Mann Act, and that's where we're sitting today. But I do believe that we had some more time, Your Honors, dealing with the letters we submit to the court, and we're doing it on an expedited basis. We get a verdict today. We get a verdict today, and we are off and running, trying to figure out what are the exceptional circumstances in this case. After we write the letter, we all say really the exceptional circumstances are the facts of the case, and so we said that to the judge. Maybe Your Honor would think about it differently. So all of this to say, I know Your Honor worked so hard for the entire trial, and I see how the court does things, and it's truly admirable, and the time the court takes. I think the issue here for us is, I think, had we had more time, I think we could have dealt with the Leia issue and the exceptional circumstances in a more fulsome way. I could tell that the court was going to be concerned about the court didn't want to run afoul of the Leah decision. I don't know that we gave the court enough in our letters to make the court believe that there was exceptional circumstances. The court speaks. Why would that matter given that I ruled that even if this were not a mandatory detention situation, nevertheless, you would have the burden by clear and convincing evidence to establish that the defendant posed no danger to the safety of any person in the community. And you full throttledly in your closing arguments told the jury that there was violence here. And domestic violence is violence. And you said that this is a case that did involve violence. Now, you told the jury that the government had failed to meet the requirements of the various charges, the S trafficking count, that the RICO charges, and you prevailed in that respect. But as to the basic questions of violence, you conceded that in your argument. Given that, and given the evidence now to be clear, as I said, the relevance of the evidence as to the sentencing is not an issue that we're dealing with. Here, the evidence, though, can be considered by the court on a bail application, and you've been there. Sometimes in pretrial detention, people come in, they're pointing out to various facts. Here, we have a trial record. And in a situation where the defendant bears the burden to show a lack of danger to any person by clear and convincing evidence, that evidentiary record, for the reasons I said, would make it impossible to meet that standard, even under normal standards that would apply under 3143A. Let me stop right here. So the judge is telling Agnifilo, hey, you guys conceded to the violence. Again, repeating himself there, okay? Right now, the burden of proof, of course, is with the government. But when it comes to bail, it's a little bit different. The defendant has to show that he doesn't have a track record of this. So based on what they've submitted in the evidence in the trial, hey, the Intercontinental video, Jane Doe's statement, they're using that again to determine his level, his risk, based on what the judges say, okay? So I'm just pointing this out here, that even though you guys in the chat especially want to dispute certain items of evidence, the judge is using it. You can't dispute it. It's there. It's his decision, right? So what the judge is telling Agnifilo. Agnifilo speaks. Right. That's absolutely true. I would note that I believe since 2018, there was one incidence of violence involving in June of 2024. That was the subject of Jane's testimony. And your honors remembers that testimony. I mean, there's an argument. We didn't need to make it because it was an assault case that Mr. Combs was defending himself. She was very clear. She attacked him first. But I think more to the point, and this starts to come out at the trial, and I think we started to bring it up, then I think there was an objection. We went to the side, and I think that for that reason, that were the right reasons. Your honor didn't think it was appropriate for the jury, but I do think it's appropriate for today. And it's this: Mr. Combs made efforts to get into a batterer's program. I know of them because Miss Garagos and I were the ones who got him into the batterer's program. And I believe Jane helped him write the letter to get into the batterer's program. It's called the Urban Resource Institute. He came to New York. He went to meetings. He participated. We have someone from there who I think will probably bring to the sentencing to tell your honor what he did. And then he got arrested. And we knew he was going to get arrested. As your honor probably remembers, he came to New York because when Miss Garagos and I met with the prosecutors, we knew it was coming. We told Mr. Combs, it's coming soon. You should come to New York and surrender. And so he came to New York to surrender. So here we are all these months later. And we have a man who came to New York to surrender, who gave his passport to Ms. Garagos and I in April of 2024, 6 months before he was arrested. We took his plane away from him and it charted through a company. We did all these things, and none of them worked at the bail hearing because he was held. And he was held in large part because he was charged with trafficking that has a rebuttable presumption of detention. But he came here. He fought for his innocence. A jury listened to the evidence. The jury acquitted him of the most serious charge. He's now basically convicted of the 2 prostitution related offenses. But the same drive to meet the case head on, honorably, like a self respecting, businessman that he is, a serious person. I mean, I think if the trial showcase was one thing, he's done remarkable things in his life. He has these flaws, his personality, which are significant, which have held him back, which have brought him into the courtroom, I think, honestly, which the jury has. We have our own issues with the conviction, but for the most part, got right. And he is a man who's in the purpose of working on himself. He's been a model prisoner. There's no small matter. He's been in a very difficult part of MDC. He's been in the unit where there are fights, where people get in trouble and go to the SHU. But he's been spotless. He hasn't had any issues in his record, and he's been truly a remarkable prisoner. There's been no issues whatsoever. I don't know of any disciplinary procedures that he's been through. And so we really do have a man who's done everything that we could to possibly ask of him, including come to New York and surrender his passport. I would call the prosecutor and say, we're happy to come down. We're happy to come down. Whatever the case wants, whenever the case wants to start, just let us know. And they didn't want to do that because they wanted to be able to hold him and get it. Honestly, the fact that we are able to try this case with Mr. Combs in jail, arguably effectively, is a testament to him. I want to thank MDC. The MDC gave us good access to him. They made it work. Your Honor helped us out a great deal by giving us access to him. But this is a man who just lived up to his obligations, who's kept his word. He came here to prove his innocence, and he did it. And he did. And he did, with the exception of the 2 prostitution counts. And I just think that we should trust, and I just think that we should trust him. He's not going to flee. He's been given his life back. I mean, this jury gave him a chance at life. He's going to have next chapters of his life. As Your Honor can imagine, I'm not going to get into a conversation lawyers have with their clients, but when you're charged with racketeering, conspiracy, and trafficking, there's all sorts of the darkest conversations one can imagine about what your life could have been and what your life became. And just at this point, Your Honor probably saw this. When I was reading the Mia message for his birthday, I had a hard time finishing it because it talked about how glorious his life was going to be. And it wasn't because look at all that's happened to him, but he did the right thing. He did the right thing. He came here. He faced the court. He's been decent with the court each and every day. And he just deserves that chance. I mean, his children are here. I know that we submitted letters to Your Honor. I don't know what, I don't want to pull heartstrings when I shouldn't pull heartstrings. But as Your Honor knows, the mother of his children had passed away many years ago. These kids, the 2 daughters here sitting in the middle of the Honor's second row, don't have a parent. And I know these are arguments we're going to make at sentencing as well. But it's very difficult on every person. And here's someone who really has done the right thing, did everything that our justice would expect of him. sat for the trial, was acquitted of the most serious charges, was convicted of prostitution charges. I know that, Your Honor, we have statutes that we condemned with, and I knew that the way the statute laid out was going to make it hard for Your Honor to release him. I recognize that going in, but I think that through a line that would allow the court to do just that, is that this is such an unusual, an exceptional set of circumstances, that the user of prostitution services is being convicted of Mann Act and is looking to get sentenced. And all the other things are really, I think, besides the point. He's been acquitted of violence, the violence to the extent that it was related to the S trafficking. He was acquitted of that to the extent there were some notions that he obstructed justice. He was acquitted of that, and we'll deal with that when we get closer to sentencing. Your Honor, put a great deal of thought into Your Honor's decision, and I recognize that, and I'm trying to give some hope to the fact that you've let me speak as long as the court has. I'm asking you to trust him, Judge. The court says, okay. Agnifilo speaks. I know he wants to talk to you. Mr. Combs wants to talk to you. But let me just see what he wants to say. The court says, yes. Why don't you confer with your client? And while you're doing that, Ms. Comey, if you'd like to respond, you may. Okay. This is when Ms. Comey, I heard, let me stop right here. I heard through the grapevine that Ms. Comey really gets into it. Okay. They really get into it. It becomes a thing here. Okay. Now hold up. Let me do something real quick. Hold up, guys. All right. Make sure you guys are hitting the like button. Let me see where we're at with the likes. I'm looking at the poll. Okay. Yes, thank you guys for getting us to 500 likes. I appreciate it. If we can get to 600, I'd appreciate it too. Support the channel. Hit the like button. Thank you. Sweet Comey. So I heard that Comey really went in. She really went in. So I kind of want to hear what she had to say. Okay. And again, I'm kind of reading this for the first time with you guys, so you're kind of getting my reaction in real time. Let me know what you guys think in the comments as well. Miss Comey speaks. Your Honor, the statute is clear. Your Honor's interpretation of the statute is clear. There's no wiggle room here. Congress' intentions was that any defendant convicted under this statute be detained. And the only thing exceptional about this defendant are his wealth, his violence, and his brazenness. He is extraordinarily wealthy and capable of flight. Any amount of time in jail is a reason to flee. He faces the almost certainty of additional jail time. His violence, Your Honor, has already hit the nail on the head with that. He's an extremely violent man with an extraordinarily dangerous temper, who has shown no remorse and no regret for his violence towards multiple victims, not just Cassie and Jane, but multiple other victims who showed courage coming here and testifying about it. And his brazenness is unmatched. As a defendant who knew he was under federal investigation for almost a year, he continued to violate the law by continuing to transport individuals for prostitution. He abused Jane viciously. The suggestion was that The suggestion was that was self-defense is insulting. He was not engaging in self-defense when he was kicking her and hitting her after she ran away from him and went into a ball. He was not engaging in self-defense when he slapped her 3 times while she was naked in the shower until she collapsed into the ground, to the ground. That was not self-defense. That was violence. It was brutality, and it was brazen. It was it was also brazen for him to continue to have rugs and clearly supplies for another act of prostitution in the hotel room where he was inviting Jane to come until he was arrested. There is nothing exceptional about this case except for his continued criminality and his willingness to violate the law. There is absolutely no basis to release the defendant until he is sentenced. We will work very hard with the defense to make sure that sentencing is expedited, but there is no reason for your honor to consider to reconsider your ruling. The judge speaks. All right, very good. Agnifilo speaks. Judge, may I add one more thing? If the court is concerned, I've heard the court loud and clear. If the court is concerned that Mr. Combs would be released to his home and then do something that intimidates, threatens, puts off another person, we can fashion conditions around that so that the door that I'm wondering if I can keep open, a crack is, I hear your honor's ruling. I do, and I respect it. Would the court be open to us going back, putting together a bail package? I'll float it by the government. I'm listening to Ms. Comey. I'm not very hopeful. Listening to Ms. Comey makes me appreciate that we have juries, but I'm very happy to try a proposal and see how it goes. And maybe we can come back to your honor with something that would address your honor's concern. The court speaks. Okay. So for the reasons I indicated, the application for bail is denied. I want to make sure that we didn't lose the thread of where I think you started, which is the reasons why this case and expedited sentencing proceeding would be in order. I've heard you on that. I think the government has heard you on that. So we'll receive hopefully a joint proposal from the parties as to how we can proceed to match that expectation of doing this in a quick fashion. We'll receive that on Tuesday. We'll have a hearing that'll we'll set, and I'll just give you the time so we can do this now. Do it at 2 p.m. on July 8th. Does either side request that be in person? Excuse me. Does either side request that be in person? Otherwise, I think it might make it easier to do it remotely. Okay. Comey speaks. No, Your Honor, but we defer to the defense on whether they waive the defendant's presence. Agnifilo speaks. Remotely is fine, Your Honor. Okay, the court. All right. So we'll do a remote conference. It's a conference, guys. Tuesday at 2 p.m. So it's going to be remote. No need to go to the courtroom. Anything further from the government? Comey speaks. No, thank you, Your Honor. Okay, the court. Anything further from the defense? Agnifilo. No, thank you, Your Honor. All right. Thank you very much, everybody. Have a great 4th of July and an excellent weekend. Okay, it's adjourned. That's it. That's it. It's adjourned. Ooh, we read all of that. It took us, what, a good 2 hours? What do you guys think in the chat? Let me know. Where do you guys stand with this whole situation? Let me know, my friends. Let's see. Let me get this sticker off on my face. Shout out to everybody in the chat. The end. Peak is like, the end. Whoa. Listen, I will say this. I said, like, I stand on what I've said. I feel like both teams did a very good job, believe it or not. I may not agree with everything. I may not agree with a bunch of things, and I don't, because that's just kind of how I am. But I think they both did a good job, regardless of where you land, as far as reviewing the case. I think they did a good job, believe it or not. I guess we'll see where everything goes here. You said, so Comey mentioned the minors. What is your take? She mentioned that. Why didn't they charge on minors? That's the question that I have. Why didn't they charge on minors? And the fact that that was even mentioned, is that something that's going to come out later on? I don't know. I have a lot of. I'm not a judge, or excuse me, a lawyer, but I do wonder if he's not charged on the first count, or excuse me, on the RICO. What does happen then to those co-conspirators? What does the government do? Because I don't think that they could move forward with that. Yes, the victims will get to speak, and then Combs get to speak. And honestly, like Deontay Nash submitted a letter yesterday. He was one that did a letter to the judge. Cassie Ventura submitted a letter through her lawyers. The lawyers for Diddy's, they all submitted letters for Diddy. I mean, everybody was submitting letters, and yesterday was very interesting. You said he may be pending indictment before grand jury on the minors. This might be a whole different case, because I haven't heard anything about minors, but this specific case wasn't about minors, so we don't know. But in the meantime, I mean, you know, this is where we're at. I think the government could have done a little bit better. I think the defense could. There's some areas in both sides that I feel like they could have done better between the government and the defense. I'm always that kind of person that's like in the middle, and then maybe look at both sides before I decide kind of where I land. But I do wonder, will inner city press be part of the conference? I don't know. That's a great question. There's this too. What happened there? What happened to the medication? You said the prosecution needed to collect more evidence before arresting Combs. Speedy trial request hurts the prosecution. Comey should have been better prepared. And that was his right to do a speedy trial, right? There was a lack of preparedness, I will say, from the prosecution side. A lack of preparedness. Then I don't know, guys. Like, this is where I kind of question everything too, because you had Gina, who literally was like, TMZ found Gina. The government said, and this is in the transcripts, we can't find Jane Doe 3, who we know is victim 3, who we know was Gina. How does TMZ find her outside of the grocery store at a Whole Foods in Las Vegas? That makes no sense whatsoever. Okay? It doesn't. What do you mean you can't find her? What does that even mean? Now, maybe they didn't want to drag her because she would have been a hostile witness, because what she said in Tasha K was completely different than what she said outside of Whole Foods. He's not a dangerous person. What? So why did you do that interview? Why did you say that then? What happened? Right? And this is honestly, like, this is, in my opinion, this is serious. Like, you can't carry a tune one way and then change it. And this is why people find, I hear the argument where people say, well, you have to be understanding of victims, but you also can't have people making allegations. She literally went on Tasha K 5 years ago and he said that he stomped a baby out of her, guys. Now, he's not being charged for that, but that was literally put out there. And then what happened? She got back with them after that interview. You can't be doing things like that and then not be held accountable for making such statements. Then she gets found outside of the Whole Foods. He's not dangerous. What do you mean? 5 years ago, you said he stomped the baby out of you. Right? Which one is it? He's dangerous or he's not dangerous? Because then that you could look at this two ways. You could say the government was pushing an agenda, or this really did happen and you just lied. Like, I don't know. It's a lot. It's a lot. But you guys let me know what you guys think in the comments about the situation. And I think Gina was the one, if I remember correctly, was it George Kaplan who said that he saw Gina being hit by green apples? And they were like the decorative apples or something? That's what it sounds like. And listen, I'm all for, like, if you're in a relationship with somebody, and it's horrible, hey, get your justice, do what you have to do. Whether that's like, I'll never kick anybody down, but I'm also for the truth, right? Like, what is the actual factual thing that happened here that led to this? If she got a settlement, that doesn't mean she can't testify. Cassie got a settlement, she got to testify. I don't know. I think that this is why people get such a bad rap, because then you also find a situation where it's like, well, you didn't report this before. And I can see that side of the argument. Let me tell you guys something. Like, um I'm a social worker by trade, right? Like, I research and but I have been on both ends of the coin as a social worker. And this is why I think it's important to see both sides of a story, of a case, okay? When I worked in government for 10 years, and I've had all kinds of cases, right? All kinds of cases. And I remember, I've had the cases where kids have been violated by their parents, right? Horrible, horrible thing. Okay. But then I've also had the cases where kids have violated other kids, right? Now, some of that behavior is learned behavior, some of that is generational. Somebody violates somebody, it's usually in the family. I'm not on the mindset that if a child who's under the age of 13 violates another child, and you know what I mean, because they can pick up charges, right? That I have to throw that child away. I believe that there's treatment for the child, but we have to address it right now, so that when you turn over the age of whatever it may be, you're not violating adults. You're not creating victims. There's a cycle there. This is why it's important to look at both sides of the argument, both for the prosecution and the defense, because there's always an underlying story of trauma behind that. I'm telling you, very likely the child that is violating other children have been violated before, and they don't know how to cope, or they don't know how to deal with those aggressions and those horrible behaviors. What do? They cause other victims in their realm. I've seen it too many times. That child also needs representation, right? I've seen it. You don't throw the person away. It's a little bit different when they're adults and they're doing all of this and they have had ample opportunity to address those issues. But what do? They become perpetrators. They become your Ted Bundys. They become, all these other people that go out there and they hurt people. But when they're children, it's a little bit different, right? So that's how I see it. When we talk about Diddy, even though it's very hard sometimes to really, even if you're pro victim, it's so hard to see at one point Diddy was a victim of something, right? Like, you kind of have to wonder who perpetrated on him. What did he see in his childhood? Because a lot of this is a lot of generational stuff that happens that we see, right? You have to be able to look at things both sides. And even for Cassie, it doesn't escape me, guys, that Cassie was dating at 19, was dating a 16, was it? She was dating was dealing with much older men in the industry. Okay. That doesn't escape me. So a lot of this is repeated behavior. You have to kind of wonder, well, where did this come from? When did Cassie's her mom didn't intervene? Her mom didn't say, hey, yeah, you're in the industry, you want to do this, you want to be famous, however, I got to step in because you can't be dating this older guy before Diddy. Okay. A lot of this is repeated generational behavior. So working in government and having these kinds of cases and looking at all sides and ends of the coin, you start learning that typically there's cycles of different things. And even though, some of these kids are they might be victimizing others and victims, there's a cycle there that never got stopped, and it just continued. And here they are at the age of 35, 25, perpetrating on other folks. You have to be able to look at all ends of an argument. And so when I get people that only want me to run a certain narrative, I struggle because I always look at that other side. You have to do it. You said, Rabbit, did you see the alternate juror on CNN? No, there was an alternate juror up there. Okay. Who? When, why? Let me know. CNN gave an interview. Oh my God. And BJ, I was inside the courtroom for conviction. First time thoughts. Oh my God. BJ just did a video. Hold up. There was a Diddy juror interview. Let me see if I can pull it. No, I don't see anything. It was an alternate? Okay. Did they say their name though? Jury, Diddy jury interview. CNN, you said? Let me see if I could pull it. Mm-mm. Oh, okay. Hold up. Who is this? Nah, I don't see it. Go to TMZ. Okay. Oh, see, y'all tell me to go to TMZ, and then you guys get mad at me when I go to TMZ. The jury leaves in a van. Man, that jury was like, let's get out of here. Oh my God, do we have images of these juries? Oh, hold up. Let me show you guys. I know people get mad at me. You're looking at TMZ. Well, y'all telling me to go look at TMZ. The jury moves. It's not playing. Okay, there's the judge. Damn. See, they had people out there waiting for this jury. It's not playing. I guess we'll wait. Let me see if I can pull it, y'all. Because I don't see it. Details from inside the courtroom. That's details from inside the courtroom. No, I don't see it. You're going to have to give me more information. It's not CNN. Sorry. Okay. Is it TMZ? TMZ, man. Of course it's TMZ. I don't see, but this is not moving. And it's not my internet connection's great. So maybe they took it down. I'm not sure. You already knew that they were going to be in there. TMZ. Let's see. Oh, this just released 43 minutes ago. Diddy trial alternate juror was spotted with Diddy's conviction. This guy right here. It's not playing. It's this guy right here. One of dirty. Okay, let me see if it is CNN though. You were right. Let me see if I can pull it on my, and I don't know why it's not playing. I'm going to type in the title. It's 1-on-1 with alternate juror in Sean Diddy Combs trial. Nope, it's not up yet. It's not playing. Let me see what they said though. See if I can find it. It's not playing. I wonder why. Okay. Anyways. And it goes. An alternate juror on the Diddy case has spoken out and says he agrees with the surprising verdict confirmed Wednesday that acquitted the musician of the most serious charges of the federal government leverage against him. The unnamed juror sat with CNN Thursday. Today, he says his 350 pages of copious notes led him to agree with the jury that Diddy did not commit any trafficking or racketeering crimes. Remember, he was only convicted of 2 of the lesser charges of transporting prostitutes for S. The jury's reasoning during the riveting and eye-opening trial, the prosecution was not able to prove RICO and charges beyond a reasonable doubt. Even with the prosecution showing Diddy participated in sexual intercourse, the jurors said the activity didn't seem forced and was even pretty tamed, mostly showing baby oil being rubbed and on those involved in the S acts. Further explained that the text presented by the defense showed there were levels of consent with Diddy's sexual encounters. He also touched on the very bad 2016 video of Cassie being beaten to a pulp, said beaten to a pulp by Diddy multiple times, and confirmed it didn't make a difference when considering the charges brought against the disgraced music mogul because he was not charged with DV. Okay. As you know, Diddy and his family were thrilled when he got off the hook for the three most serious charges. He even caught his mother, Janice, flashing a thumbs up outside the NYC courtroom after that verdict was read. Not everyone is happy. Don Richard, who was pending a lawsuit against her former mentor, called his 2-count conviction a disappointment in a statement via her attorney. She made a statement. Diddy remains behind bars as he awaits sentencing. Okay. I wonder why it's not playing. It's not playing. Okay, let me see if it's on YouTube. Yeah, I don't know what's going on. I think TMZ is having an issue because my internet is fine. Alternate juror Diddy. No update. It's not up yet. It's literally just hot off the presses when it comes to this. That is crazy, guys. That's crazy, crazy. Okay. Well, wow. Let me know what you guys think in the comments. I think I'm gonna be done here because my vocal cords are fried right now. Let me know what you guys think in the comments. I'll see if I can find it. It's not playing though. Literally, it's not playing. Nothing. And neither is the other one for the van. I guess he said everything was pretty tame. TMZ don't want the smoke with the federales. Yeah, I'm gonna go get something to drink and stuff like that. Johnny, thank you so much for gifting 1 membership. Thank you, Johnny D710, and Alejandro. Thank you again for the 199. All right, guys, I gotta go because I gotta go get some rest on my throat. But shout out to you guys. Let me know what you guys think of these transcripts, and that's it. No more transcriptos. I think we're done. Right? I think it's done. It's a wrap. Go home. I'll see you guys. Make sure you guys hit the like button. Bye, guys. Bye.